I see no reason the bond should even be at 500, Your Honor. Besides this case, he has a weapons charge also pending that predates this murder, a misdemeanor, involving a firearm. He's been in fights in the jail. He's done nothing, that would, I don't.
Good morning. Are you Eleazar Stansberry? Eleazar, and Mr. Stansberry is charged with murder in cause number 26 DCCR 0174. And it looks like Mr. Burbank has filed a motion asking that bond be reduced. It's currently set at $500,000. Mr. Stansberry, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you, Mr. Burbank.
Please for the record statement.
Eleazar Stansberry.
Eleazar, we're here to request a bond reduction, is that correct?
Yes, sir.
It's currently at 500,000.
Sir.
Do you have any bank account with any substantial money?
No, sir.
Speak up.
No, sir.
And do you have any IRAs, retirements, any type of property that you could possibly put up as collateral?
No, sir.
You were asking that the bond be reduced,
Yes, sir.
and so that an amount that you'll be able to make, is that correct?
Yes, sir.
You have, if you are able, if the bond is reduced, will you be able to stay in the area?
No, the last time I came, Miss West told me I can go to girlfriend's house in Harris County.
Okay. And so that's where you be staying?
Yes, sir.
You know that you would have to get a GPS device.
Yes, sir.
And there'll probably be some rules and regulations, I believe, that the judge probably set for you in reference to where you could go and where you couldn't go.
Yes.
And would you comply with those rules?
Yes, sir.
Your Honor, before I was court appointed, I think Ms. Holmes asked for a bond reduction.
I don't see that there was a motion.
No,
That's what I was looking for.
yeah, I mean, I went out there. I went out to see Mr. Stansberry, and in between there and Ms. Holmes, I guess he was on a docket or something, he requested that it be reduced, they reduced it down to 500,000. Before.
So what's changed then? If I've already reduced it?
Well, since then, yeah, since then, he has tried the 500,000. This is my first bond hearing, Judge, and I don't know why he got in front of you before, but it did.
Yeah, I see that it was initially set at 1.5 million,
Right.
reduced to 500,000.
We're asking Judge that it be reduced down to 150, 175.
Mr. Nichols?
I see no reason the bond should even be at 500, Your Honor. Besides this case, he has a weapons charge also pending that predates this murder, a misdemeanor, involving a firearm. He's been in fights in the jail. He's done nothing, that would, I don't understand why we got down to 500, to be honest, Your Honor.
Well, and I don't recall, and I don't see anything in the case on that either. So, yeah, I think at this point, based on the nature of the offense, I have taken judicial notice of the court's file, which includes the probable cause affidavit. There's not a whole lot of information in it, but enough that I believe that based on the offense charge, the fact that there's already been a bond reduction and what Mr. Nichols has provided with regard to another underlying weapons charge, I'm going to deny the motion to reduce the bond any further at this point. So we'll reset a case and get it for an announcement as quickly as possible.
If we could, Judge, we'll be able to announce it next.
All right, thank you. You can go back with the bailiff.
Big seat, Your Honor.
Thank you.
So I'm going, in cause number 14-18993, I'm going to take judicial notice of the court's file. This is Alan Wayne Bell, who was found not guilty by reason of insanity, I think back in 2014, or something like that. 15. Mr. Bell has signed a waiver of appearance for today. Let's see, that was signed and dated March 18th. And Mr. Parker, do you agree with going forward with this hearing without Mr. Bell present?
I do, Your Honor.
All right, so what I want to do though, so we received a report well, that's dated, February 17th from, the Rusk State Hospital. And that was, sent by Dr. Holland. And their recommendation at this time is that inpatient treatment is no longer, indicated, at this time, and they have come up with a potential plan for Mr. Bell to be potentially, released to a less restrictive, placement. They sent me that information on what they're recommending. Hold on just a second, let me find that. This is 34 pages long, but it's, shh, sorry.
This is just all got JoJo that helps expedite it for you.
So it's a community integration project.
I've got that same documentation, Judge.
And what I had intended for today was to have someone from the placement be here and testify, about that specific placement so that I could get more information. I'm also, would like to potentially, done this in the past, and I think maybe might be warranted in one, something like this, actually go to the placement. I've done that with the defense attorney and the prosecutor before on one where we took a trip and actually looked at it. So that I could get a better feel on whether or not I felt comfortable with the level of, I guess, protection and how they're, anyway, just what it looks like. So that I would know if I felt comfortable releasing Mr. Bell to this specific, placement. And so since what I'm going to do now that we've started the hearing, we have some time constraints, I'm going to, hold and, carry the hearing forward. Ms. Carter is going to find out,
Yes.
when we can have someone here, and we'll have just a hearing, quick hearing, so that on the record, they can say what level of care it is and how many people they have working there and the protections that they have if something goes wrong and he doesn't take medication and all those things, and then I'll make that decision. But in the meantime, maybe we can get together and, I at least want to go lay my eyes on the place. And so if y'all want to take a field trip with me, we'll go do that and, see where it is. And, that way everybody has a little more information before we're arguing for or against it and things like that.
Just for the record, Your Honor, they've called me 2 or 3 times over the last this year since January, and
Who's that?
the facility well, where he is now,
At Rusk?
and basically, reiterating what you've expressed. And Mr. Bell, he's called me numerous times, and I've talked to him several times, and he's like, "Why am I still here?" He said, "Why are you still there?" And I said, "We're gonna have a hearing." When I talked to the facility, I expressed to them, I can't, I'm not an expert, and I don't know his condition. I just got to base it off what they say, but that they need to talk to the court about coordinating whether they need to be at the hearing or Zoom in or something. So,
Well, and what we'll
No.
do, obviously we have this, a very detailed, report that they sent.
Right.
And if anyone would like any of the people that I guess had a part in that report and examination to make the determination that he potentially does not need to be there anymore. If you want any of them, they're easy to Zoom in. And so maybe, what we can do is get them. I think we need to have everybody that we possibly can. And I've been, part of what I did in the past on one of these was actually go to Rusk itself. And so it is important. A lot of people think that, and there's part of Rusk that is very locked down. Where he is and I can't remember what it's called, the unit that he's in is literally they could walk out. There's no fences, there's no locks, there's no anything. If you're in that part of it, you're already really easily in the community if they wanted to be. And so it was a little eye-opening to go there and realize that it's not such a stretch sometimes for them. If they've been in that, they've been in it for a long time. They were somewhere else in another unit for a long time. They have to prove things. I sign things all the time for Mr. Bell and some others to go on community outings. There haven't been any issues. And so it sounds a little sometimes scary, but where they are now and that unit that they're in is extremely, they have rules. And if you don't follow the rules, you get sent back to the other part. And so they have a lot of freedom. And he's been doing well apparently in that. So let's hold the hearing. We'll set it for in a week or two when everybody's available. And in the meantime, we'll get some more information about that later.
Sure.
All right,
Thank you.
thanks. Ms. Perazzo on Traylon Hill. Morning, Judge. Morning. Don't need to look at it anymore. I've got, here's your copy. I forgot to get back to you yesterday. Were you gonna say roses are red?
It's a coffee.
Please tell me that we're ready to go ahead and get it set for tomorrow.
So. Was there? It's like a 10-year
That was old, way old, and then he
Okay.
kept acting up. It's all for.
Good.
Nice to see you again. You got me quick, huh?
Good morning, you're Traylon Hill?
Yes, my wife was.
Good, and so, I'm going to take judicial notice of the court's file. The last time we were here, we wanted to double check and make sure that there were not issues with regard to competency based on some of the behavior and, things that Mr. Hill was doing and saying. And so, we had Dr. Rapon do a, competency evaluation. I received that report dated January 24th. Of this year. And in that report, the finding is that Mr. Hill is competent in stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
None in regard to competency.
All right, then at this time, based on that report, I am going to find Mr. Hill competent to stand trial. Ms. Perazzo, it is, I know you are a little newer on the case. We've gone through some attorneys, but it is time for either a trial or a plea. So I need to know today if you want to visit with him in the back real quick. Whatever the latest offer is, if he wants to reject that, we'll get it set on the very next trial docket. If not, I want it taken care of this morning.
Yes, ma'am. And
I'll
if I
hold
could
it.
Get that offer.
I'll hold that. All right, go back to the bailiff.
Okay, I'll maybe give you a judge.
The gavel strikes the wooden black, but for Eliezer Stanberry, the sound is a death sentence for his hope. Accused of murder, he stands shackled in a quiet courtroom, his voice barely a whisper. "No, sir," he repeats. No bank accounts, no retirement, no property. His entire defense rests on a promise to behave and a girlfriend's address in Harris County. Defense attorney Burbank pleads for a reduction from $500,000 to a mere $15,000, arguing the man is too poor to flee. Then prosecutor Nichols strikes. He reveals a weapons charge predating the murder, a misdemeanor firearm offense. Worse, Stanberry has been brawling inside the jail, violent even while awaiting trial. The judge, having already reduced the bond once from $1.5 million, sees a pattern of danger. He denies the motion coldly, leaving Stanberry to rot in a cell. But the transcript does not mourn. It pivots to Alan Wayne Bell, a man found not guilty by reason of insanity years ago. Now, doctors say he no longer needs inpatient treatment. He calls his lawyer from the hospital, confused. Why am I still here? The judge considers a field trip to the placement facility, noting that Bell's current unit has no fences, no locks. He has been taking community outings without incident. Yet the court hesitates, haunted by what happens when the meds stop and the mind breaks free. 2 men, 2 cages, one locked for violence, one unlocked by insanity. Both ask the same question. When does the system stop protecting us and start punishing us for surviving?